Hello, everyone, and welcome to the semifinals. Congratulations on making it here. Just as one second last reminder, please, competitors, keep yourself muted unless you are, of course, speaking. Justices, you may keep yourself unmuted or muted throughout the round. It's completely your choice. This round, you'll have 14 minutes per speaker. So I'll be giving you visual time cues using these. One at the 3 minutes left, so at the 11-minute mark, at the 1 minute left mark, so 13-minute mark, and I will verbally and visually show you that it's time at 14 minutes. Please ensure, of course, that your computer notifications and phone notifications are muted. And as a reminder, please do not show or tell the justices what your school affiliation is. We may also take photos for the social media during this round as well. And unless there are any questions for me, we can get started as soon as the justices are ready.
Is everybody ready? Okay. Sorry, just to clarify, because I just stepped out for a brief moment. Can the appellant advise who they are?
We're the appellants. I'm the first speaker. My name is Rebecca Tiley.
I'm the second speaker. My name's Avery McKinley.
Okay, you may proceed.
Good afternoon, honorable justices of the court. My name is Rebecca Tiley. Here's my colleague Avery McKinley, and we are here on behalf of the appellant, Her Majesty the Queen. At issue before the court here today is that reconciliation under Section 35 between Aboriginal peoples of Canada and non-Aboriginal peoples of Canada requires that both groups live and contribute as part of our national diversity and does not extend to those who are not part of Canadian society. Therefore, it is the appellant's position that the Supreme Court of Canada erred in determining that Sections 11(1) and 47A of the Wildlife Act are of no force or effect with respect to the application of Section 35 of the 1982 Constitution Act to Mr. Desautel, the respondent. We respectfully request the Honorable Supreme Court of Lions Cup to allow the appeal, overturn the lower court's decision, enter a verdict of guilty, and remit the matter to the trial court for sentencing. Would the court require a brief summary of the facts? To this end, the appellant has two submissions to make today. I will submit the first, and my colleague will submit the second. The appellant's first submission is that Section 35 of the Constitution Act does not extend to protect Aboriginal peoples who are located outside of Canada. The second submission is that the Supreme Court of Canada erred in their assessment of the continuity requirement in the test for Aboriginal rights. To begin with the first submission, before determining if Mr. Desautel has a right to hunt and satisfies the test for Aboriginal rights, the court must first answer the question of whether or not, as a member of the Lakes tribe who resides in Washington state, he's included under the scope of the phrase in Aboriginal peoples of Canada under Section 35. Section 35 has both a generalized constitutional status, but also grants special constitutional protection to one part of Canadian society. And as stated in the 1996 Supreme Court of Canada case of the Crown and Vanderpeet at paragraph 20, the court must lose sight of neither. Section 35's specialized constitutional status comes from the fact that Aboriginal rights have their source in the past, and this is unique to Section 35. What gives Section 35 its generalized constitutional status is that the holders of those rights, the individuals who exercise Section 35 rights in the present, are part of Canadian society. This interpretation of Section 35
Counsel, you mentioned that the Aboriginal rights are based and informed from the past, but that they're exercised in the present. I'm wondering if you can address any policy considerations flowing from those statements.
The policy considerations that we will address today are first that opening up the scope of Section 35 includes not just in the case at bar, the right to hunt, but also other Aboriginal rights such as title claims and land claims, and also the duty to consult, which my co-counsel will elaborate on further. This idea that Section 35 has both a generalized and special constitutional status is supported by the linguistic context of Section 35 and also by the Section 35 jurisprudence. To turn first to that linguistic context, while analysis must bear in mind the purpose of Section 35 and give a generous interpretation, it needs to be set in the proper context of the provision. And to turn to the linguistic context of the provision within the Constitution of Canada, the word of is used with reference to a place that imports dwelling, and of is used in conjunction with Canada, which is a clear geographical location. And so taking together of Canada within the Constitution means dwelling within.
So you're talking about the words of Canada, how they have to be taken together, but that has to be taken with the word Aboriginal as well. And Aboriginal refers to people who were here originally. So can't the phrase Aboriginal peoples of Canada, does that not refer to those who were here originally in what is now Canada? And would that definition not include Mr. Desautel?
We submit that no, that definition does not include Mr. Desautel. And I direct the court's attention to the 1998 reference accession of Quebec, where it emphasizes that while the Constitution is made up of individual elements, those individual elements are still linked to the rest of the Constitution, and so must be interpreted with reference to the Constitution as a whole. And so we submit that the words of Canada within Section 35 must be interpreted in line with the rest of the Constitution. It's assumed that the drafters chose these words deliberately, and there's a presumption against tautology and also a presumption against consistent expression throughout the Constitution.
Okay, counsel, when you say that the words of Canada have to be interpreted in line with the rest of the Constitution, to what rest of the Constitution are you referring? Is there a spot in there where of Canada is defined?
We would refer to how of Canada is used in Section 3, 6, and 23, Citizen of Canada, Section 16, Official Languages of Canada, the Government of Canada in Sections 20, 32, and 36 within the Constitution.
Counsel, those are all different terms with different meanings. Aboriginal necessarily has a reference to the past. So are those really insightful to how we interpret Aboriginal peoples of Canada?
Aboriginal rights do have their source in the past, but the interpretation that we're submitting today is that while the rights arise from an era before sovereignty and from a much earlier age, and then were elevated to Section 35, the holders of those rights, because they exist in the modern context, have to be considered within what is now modern day Canada. And in the 2001 Supreme Court of Canada case of Mitchell and MNR, at paragraph 113, it states that Aboriginal rights, while they do have that earlier source, are projected onto modern Canada by modern Canadians. The Section 35 jurisprudence characterizes reconciliation as an ongoing process between Aboriginal peoples and non-Aboriginal peoples as full and equal members of Canadian society. The Constitution was drafted in 1982, and it is not our position that it's set in stone in what the drafters intended in 1982. However, if it is going to expand beyond the meaning of the drafters' intent and the words that were used in 1982, it must be in line with the purposes of Section 35. And to turn to how the jurisprudence has characterized that reconciliation, first, the case of Mitchell, where it elaborates on the relationship between Aboriginal and non-Aboriginal peoples as a merged or shared sovereignty in which both groups are partners. And that point of participation in Canadian society is also emphasized in Mitchell. And in order to move forward with that broader purpose of reconciliation, it has to be set within that modern context.
But counsel, how can we talk about reconciliation when we have international borders imposed and factors, action by the Canadian government, which forced out or contributed to the movement of the Sinix people to the US? How is that in line with, how is your definition in line with reconciliation?
So reconciliation within the legal order is not without limits. And that's noted in the 1996 Supreme Court of Canada case of the Crown and Gladstone, where at paragraph 73, it states that because Aboriginal societies exist within and are part of a broader social, political, and economic community, the same way Aboriginal rights are part of a broader picture. And there are times that within the process of reconciliation, limits placed upon those rights are also part of that process. And so how reconciliation takes place within the Canadian legal order is through Section 35. Section 35 itself serves to act as a legal basis for which Aboriginal rights can be considered. However, like the rest of the Constitution, there are necessary limits on that. And in the case at bar, the limits are that it does not extend outside of Canada. The reason why—
okay, but Counsel, the Constitution itself can't extend beyond Canada because it is a Canadian piece of legislation. But I'm not convinced that relying on a linguistic interpretation of the terms of Canada necessarily means that a group that can show a connection to a Canadian Indigenous group can't qualify, as has been held by 3 lower courts in this particular case, can qualify to exercise an Aboriginal right within the Canadian border. So I'm just wondering if you're not putting too much stock in the interpretation of the words of Canada and failing to address the fact that there are groups that are not allowed to stay in Canada.
Besides the linguistic context, we would also rely on the Section 35 jurisprudence. And besides the case of Mitchell, we would also rely on the case of Vanderpeet, and specifically paragraphs 20 and 21 of Vanderpeet, which emphasize that Aboriginal peoples and the rights holders of Section 35 are also part of Canadian society, but also at paragraph 48, where the court explicitly referred to Aboriginal peoples as Canadian citizens. In the case of bar, the reason why Section 30—
I'm curious to know if you have a policy submission in light of the social context of Indigenous people and the government of Canada right now. I want to know what you would say to people if we were to take your position. What would that mean in the social context that we're living in?
The reason why limits fit in with that grander purpose of reconciliation under 35 is because what of Section 35's ultimate goal is, and it is reconciliation, but within the legal order, and it provides that legal basis for Aboriginal rights within the Canadian constitutional frameworks. And these limits are necessary because they allow Section 35 to be framed in terms that are compatible with the existing constitutional structure. And as the court noted again in Vanderpeet, that Section 35 has both that specificity, but also generalized constitutional structure. And if it were to lose that generalized constitutional structure, then it can no longer—
Okay, you're speaking, sorry, Counsel, you're speaking of structure and fitting within the greater constitutional structure, but you also have to understand our Constitution is a living tree, and it is able to change with what we know now. It isn't something that we carved in stone. So again, I'm going to point to the fact that 3 lower courts have indicated that there is room for people like Mr. Desautel to exercise rights here. And I'm wondering if there's not a middle ground between saying absolutely not and saying, yes, everyone can come and exercise their rights here. Not room for some—
I'm sorry, you cut out a bit, but if I understood that question correctly, it's whether or not within this broader process of reconciliation and the fact that reconciliation is an ongoing negotiation process, if we could not take that step towards. Because of how the Section 35 jurisprudence has characterized reconciliation, we would submit that to lose the generalized constitutional framework of Section 35 within its broader status within the Constitution would mean that Section 35 is no longer able to serve as that legal basis for existing Aboriginal rights, and that would cause complications with that.
Sorry, are you saying that expanding Aboriginal rights in order to adopt to current society would somehow degrade Section 35 of the Constitution?
Because as the court noted that Section 35 has both that—
No, I'm asking you about your argument. You just suggested that there would be sort of a degradation of Section 35 of the Constitution to allow this expansion. And so I'm asking you to just clarify as to whether or not your argument before this court is that increasing the rights of Aboriginals to include those who are no longer on Canadian land would somehow degrade Section 35 of the Constitution. Is that the argument you're making?
Yes, that's stretching the meaning of Section 35 too far away from what already is within the constitutional framework, as set out by the linguistic context and also by the jurisprudence, would no longer allow Section 35 to achieve that purpose of reconciliation, of providing that framework for Section 35 rights. An analysis of Section 35 that is guided by its grander purpose of reconciliation, grounded in the relevant jurisprudence and linguistic context, establishes that phrase can only apply to people who are participants of Canadian society. Barring any further questions, that concludes the submission on behalf of the appellant. Thank you.
Good afternoon, honorable justices of this court. My name is Avery McKinley, and I will be concluding the final submission on behalf of the appellant, Her Majesty the Queen. Our final submission is that even if the scope of Section 35 can extend to Aboriginal peoples located outside of Canada, Mr. Desautel has not met his onus of establishing continuity under the Vanderpeet test for an Aboriginal right under Section 35. My submission will proceed in two parts, the first addressing continuity under the Vanderpeet test, and second addressing public policy considerations. The majority cites the Vanderpeet test, which was restated in the 2011 Supreme Court of Canada decision of Lequalam's Indian Band in Canada. The three-stage test is first, to characterize the right claimed in light of the pleadings and evidence. Second, to determine whether the claimant has proven that a relevant pre-contact practice, tradition, or custom existed and was integral to the distinctive culture of that pre-contact society, and to determine whether the claimed modern right is demonstrably connected to and reasonably regarded as a continuation of the pre-contact practice. The 1996 Supreme Court of Canada decision of the Crown and Vanderpeet itself states that in determination of the scope of the rights, the basis of the facts as the trial judge finds them is a question of law, which mandates no deference from this court. We do not take issue with the facts, but we do take issue with the interpretation of that evidence as to whether those findings of fact support a claim to the existence of an Aboriginal right under the Vanderpeet test. The only evidence provided at trial in establishing continuity is that the Lakes Tribe engaged in a seasonal round of hunting in Washington at the time of contact, and as stated by the majority, that the land was not forgotten in the minds of the Lakes Tribe. We submit the evidence of hunting in Washington is irrelevant to establish the right to hunt in a different area of land, in this case, because the connection to the land is site-specific and it maintains a site-specific requirement. The 2006 Supreme Court of Canada case of the Crown and Sapieha states that the character—
Okay, so Counsel, I have a question for you. You're talking about maintaining a site-specific right. How is one to do that when there's now an international border and a set of laws saying you can't hunt without a license? So how are we to square what was their ancestral hunting ground with the realities of the modern world? Are we to just take the right away because the government decided that there was a border and the government decided that they would require licenses to hunt?
No, Justice. In fact, in paragraph 133 in the case at bar, it states that the Lakes Tribe continued to hunt in, the Sinaiks continued to hunt in the 1930s despite the border, and this does not explain the absence from 1982 to 2010 in British Columbia when their rights were constitutionally affirmed. Sapieha states that the characterization of the claimed right imports a necessary geographical element and its integrality to the cultures, which should be assessed on this basis of the site-specific requirement. In response to the majority's reasoning about continuity existing in the minds of the Lakes Tribe, continuity requires a maintained connection to the claimed right that is beyond what is in the minds of the claimants. This one instance of where it was in the minds of the Lakes Tribe members is not sufficient to demonstrate a reasonable connection to the pre-contact practice, because there's no explanation of this meaning that is properly cognizable by the courts. The evidence.
Okay, so what would be evidence of enough of a connection? Because the paragraph you cited to me, 133, indicates that the Lakes Tribe was absent for a period of some 30 years. Are we to extinguish a centuries, thousands of years old right because of a 30-year lapse?
No, Justice, and we are not asking to extinguish a right, but to address your question about what sufficient evidence would be, it would have to be something that is properly cognizable by the courts. And while this must be determined on a case-by-case basis, an example in the Pekotomuhkati Nation case could include archaeological evidence or oral evidence, or perhaps a treaty agreement.
But counsel, wasn't oral evidence given in the trial of Mr. Desautel's connection to the land, how he felt when he came to British Columbia?
Yes, Justice, that would fall under the category of it being in the minds of the claimants, however.
Sorry, counsel, why are we discussing the evidence? The trial judge made a decision. Should this court not defer to that decision?
No, Justice, because it is the conclusion drawn from the evidence that is a part of the legal analysis. We also submit that the last record of hunting.
So I have a point of contention that you made to one of my co-justices when you said that Mr. Desautel's evidence would not be considered oral tradition, but would be considered evidence in his own mind. It is not concept, or is not line of thinking and reasoning colonial in itself. What would qualify in this case of oral evidence in your standards?
It would have to be at a conference between perhaps Aboriginal groups, or perhaps in the ongoing relationship between the Aboriginal groups of Canada and the non-Aboriginal groups, or the group of the Crown, which actually brings me to public policy.
I don't understand what you just said. Can you clarify that, please?
Yes, Justice. So a way for the oral agreements to be considered proper evidence would have to be in a term that is cognizable by the court. So there would have to be a record of this shown. There is unfortunately no record of this in order to establish continuity.
Counsel, doesn't Delgamick talk about the Supreme Court of Canada accepting oral evidence by Indigenous groups? So, and I don't remember, and I don't recall in that decision anything being referred to in conferences or, general synopses by an Indigenous group versus a non-Indigenous group. That's not the standard. That's not the threshold in Delgamick.
Delgamick was a case regarding an Aboriginal title claim, and I believe there was treaties involved in that case. So the facts in that case are inherently different, as the Vanderpeet test stated in this case is about an Aboriginal right, which is a different form of the test. Should the justices side with us today, would not be undermining reconciliation. The only fair and just reconciliation, as stated in the Vanderpeet decision, is one which takes into account the Aboriginal perspective and the courts, and that true reconciliation will equally place weight on each. Practical implications regarding the duty to consult would run counter to—
I'm sorry, but aren't you dismissing the Aboriginal perspective by rejecting the oral evidence of the accused in this case?
No, Justice, because we are considering it, but we also have to consider it in equal consideration with whether the courts can properly understand it. The courts are not able to understand this evidence truly in terms of its meaning.
I'm sorry, are you suggesting the courts are not able to understand the oral evidence of Aboriginals as a general policy?
No, Justice, it is the fact, as stated at paragraph 136, that there's no explanation of what this means in the minds of the Lakes Tribe, of that continuity existing in their minds.
Can you, if we were to side with your argument today, what sort of message do you think that we're sending to the Aboriginal community at large?
it would run counter to accommodating the interests of Section 35(1) rights holders within Canada. The majority states that Aboriginal groups located outside of Canada may be implicated to a different degree than those in Canada.
Counsel, there are groups within Canada that have territories and members across the border. That argument that you're raising just cuts those people off. What is your response to that?
Justice, if an Aboriginal group is entitled to exercise Section 35(1) rights in Canada, it must have equal protection under the Constitution and be able to access a full panoply of rights in the same way as rights holders within Canada would. Nothing less would uphold the honor of the Crown and further Canada's ongoing reconciliation process with its First Peoples. Aboriginal groups outside of Canada would in fact be implicated to the same degree, and therefore the Crown.
Counsel, so are you saying that yes, the respondent here should have access to those rights because of what you just said?
No, Justice. If we are looking at the majority's reasoning, this is what would essentially happen if we were to give those rights based on insufficient evidence, might I add. And this would essentially result in a two-tiered consultation process which would essentially run afoul to the obligation of a process of fair dealing and reconciliation with all Aboriginal rights holders within Canada.
Counsel, the court did state that there is no obligation on the Crown to seek out Aboriginal groups, and the onus is on the groups to make their notice to the Crown. What would be your response to that?
We take issue with that, Justice, because the onus should be on the Crown, because putting an additional burden on Aboriginal groups is simply unjust. However, if we were to allow for this right to be established and essentially impose the duty to consult, this could lead to title claims and would essentially open up a lot of issues with the duty to consult. The 2011 BC Supreme Court case of Campbell in British Columbia shows
So
that
you would impose an obligation on the Crown to consult with groups whose rights you would deny exist. Is that what you're suggesting? Because I'm kind of hearing that you would not expect the group to approach the Crown. However, you also don't support those groups from having rights at all. So I'm wondering how we got there, I guess, is my question. I mean, ultimately my issue is, what is the great evil we're trying to avoid here if we allow this appeal? What is it? What thing are we trying to avoid happening? Because there have to be policy considerations here. What is the concern that that the Crown actually has about extending these rights?
So if we were to extend these rights, this would result in a two-tiered consultation process, siding with the majority's reasoning as stated at paragraph 76 in the case at bar, which would essentially run afoul to the obligation of engaging in a fair dealing process of reconciliation. This would also lead to the implications of the Lakes tribe filing, or other tribes located outside of Canada filing title claims, as the Lakes tribe did in 2011. The reason why these claims were unsuccessful is because they could not establish if the claimants were entitled to a Section 35 right, which makes this concern in no means hypothetical. While this is not a direct issue of this case, the next issue would be whether they're entitled to a title claim, and that people located outside of Canada would be able to decide how the land is used and the right to benefit off of those uses.
Counsel, aren't you jumping ahead of yourself a bit? We have a separate test for Aboriginal title claims in Delgamuukw. So we have another layer of judicial activity before a title claim is actually made out. So isn't your concern a bit overstated?
No, Justice, because the duty to consult, as stated in Campbell, is a very low threshold. So the duty to consult would still be implicated in this degree should you side with
the Aboriginal title, that issue that you just brought up about people across the border having claims on Canadian land, not about the duty to consult.
may I have a brief indulgence to answer your question and conclude? Should the justices side with the majority's reasoning in terms of allowing for this right to exist, this would impose the duty to consult because of the right existing, because that would essentially open up the floodgates to claimants outside of Canada claiming rights under the full panoply of the Constitution. The ultimate goal of Section 35 is to provide a legal basis for Aboriginal rights within our constitutional framework. While this court cannot undo the past, it is this court's responsibility to reconcile within the limits in our Canadian legal order. We urge this court to consider not only the practical implications of widening the scope of Section 35, but also the fact that this would be done so based on insufficient evidence. We request this court to allow the appeal, overturn the court's decision, enter a verdict of guilty on both counts under which Mr. Desautel was charged, and remit the matter to the trial court for sentencing. Barring any further questions, this concludes the submissions on behalf of the appellant. Thank you, Justices.
Thank you.
Good afternoon, Chief Justice and Justices of the Honorable Supreme Court of Lions Cup. My name is Firza Shabazz. I, along with my co-counsel, Lila Belzi, represent the respondent, Richard Lee Desautel. The appellant submitted that "of" refers to within the boundaries of Canada. However, an individual who has never stepped foot into Canada can still be considered a citizen of Canada, whereas the Lakes tribe, who have a 1,000-year ancestral connection to the land, are not considered an Aboriginal peoples of Canada, conflicts with the purposes of Section 35 of the Constitution Act. By recognizing that there was a prior occupation of the land and to reconcile their modern day existence. At issue is whether the respondent claimed right to hunt for food, social and ceremonial purposes under Section 35 exempts him from the provisions under which he was charged. The respondents will be presenting 2 submissions today. I will be addressing the first issue and my co-counsel will be addressing the second. The first issue will deal with the Lakes tribe, whether the Lakes tribe is an Aboriginal peoples of Canada. And the second issue will deal with whether Mr. Desautel has met the continuity element in accordance with the Vanderpeet test. The respondent respectfully requests this court dismiss the appeal and answer the constitutional question in the affirmative. I will be making 2 submissions today. First, I will present the importance of Aboriginal perspective. Second, the importance of belonging to the ancestral land for Aboriginal groups. Beginning with my first submission, I submit that the purpose of Section 35 sub 1 is to not only recognize and reaffirm existing rights, but to also reconcile. The proposed interpretation of Section 35 encompasses the modern day successors of the Snakes tribe, that which is Mr. Desautel. It's about recognizing that there was a prior occupation of the land before European contact that had their own autonomous societies, their own way of living and governing themselves. In addition, to reconcile the modern day existence while maintaining Crown sovereignty over them. As was demonstrated in the Queen and Sparrow, the Supreme Court of Canada in 1990 stated that the interpretation of Section 35 is to be read in a liberal, generous manner that keeps in mind not only the Crown's perspective, but the perspective of Aboriginal groups. Specifically holding the Crown at a higher regard to take in the interest of the Aboriginal groups. As well as, I'd like to direct your attention to to the case law, specifically Mitchell and Minister of National Revenue in paragraph 29. It states and recognizes the purposes of Section 35 and why we should look at it in a liberal and generous manner. it states that there were Indigenous groups prior to European contact who were here first and had their own way of living, their own legal tradition.
Okay, counsel, I don't think there's any question that, well, at least in my mind, that there is a connection to an ancestral homeland that is the subject matter of this. I wonder how you would answer the concerns of your friends for the appellants that this could give rise to a floodgate opening and there being a wide variety of claims, and how the government would need to address that should it happen.
Thank you. Sorry, Justice, you cut off at the end. So how would we address the floodgate?
How would you address the potential floodgate of claims? Yes.
Thank you, Justice. So we would submit that it is the duty that is owed by the Crown to Aboriginal groups in which they have a special relationship that is different from our relationships to the government, in which the government owes that duty of care to act in the good faith and the interest of Aboriginal groups. And it's highlighted in Manitoba Métis Federation and Canada, paragraph 30, in which it discusses that special relationship that arises from colonial practice and the fiduciary relationship between Aboriginal groups and the Crown. In Sparrow, the test for Section 35 was created to see whether there was an infringement of the right and if it was justified by the Crown. Existing Aboriginal rights.
So do you I guess I'm going to stop you again there and push a little bit more on this question. Are you not concerned, or can you alleviate my concern that this could lead to a floodgate of claims? I mean, it's a given that the Crown has a fiduciary relationship. We understand that. However, the fiduciary relationship pointed out by your friends applies only to Indigenous groups here that are in Canada. So how do we then prevent American Indigenous groups who may or may not have a connection from taking advantage of a loophole, I guess is the concern.
Thank you, Justice. Your Wi-Fi cut off a little bit again, but from what I understood, so as the appellants have addressed, that it would, sorry, moment's indulgence. Thank you. So as the appellants have addressed that this would create basically a bigger burden on the Crown, we're submitting today that it does not matter, so be it, because the Crown, because of their special relationship, this is different. And the purpose of Section 35 is also reconciliation, and reconciliation involves recognizing the prior occupation by all Aboriginal groups, whether they're, sorry, moments and moments. Thank you. So it's about recognizing that there is a prior occupation of the land, and it's for Indigenous groups and non-Indigenous groups, regardless of the European border that was imposed onto them without their consult, without taking into consideration their perspective, that they are owed that duty and they have that special relationship with the government.
Counsel, I'm just curious to know where you would draw the line. And I find that looking at the facts of this case, this long lapse in time from activity that's taking place, and certainly you could see and you could understand why there'd have to be limits placed on these rights. If Mr. Desautel is not a resident of Canada, where would you draw the line?
Right.
If not with him, where?
Thank you, Justice. Well, it's not in my hand to draw the line, and by drawing the line, we're also undermining the perspective of Aboriginal groups. And there was, as my co-counsel will further address, that there was no gap. There was no gap, and the practice has been continuing and still continues till this day. And both perspectives of the Crown and Aboriginal groups are required to further reconciliation. In addition, it was demonstrated by Professor John Burroughs in Earthbound Resurgence, Indigenous Resurgence, that even though Aboriginal groups may have been removed from their physical ancestral land, they're still connected in their hearts and in their minds till this day. Their roots, worldviews are implemented in their ancestral land. Secondly, I submit Indigenous groups like the Lakes Tribe Center Focus are their ancestral connection to the land. In this situation, Mr. Desautel has that connection to his ancestral land in BC.
Is there any evidence apart from Mr. Desautel from the Lake Tribe that there is a connection to this land?
Right, so if we could go to the trial judge's finding in paragraph 125, other than Mr. Desautel, there was another member of the Colville Lake Tribe, Michael Marchand, who states that when he was asked about what it meant for him to be hunting on the land of his ancestors and to be on that land, he stated that, and we try, even though we can't go back in history and exactly duplicate those things, today we can go back to the best parts of our traditions and bring those into the future. So Arrow Lakes land is one of those things.
So counsel, are you relying on these oral recitations? Do you have something more?
Right, we are relying on the oral recitation because oral history is accepted by the courts in according with Dalgamuk and the Queen. And this was their way of practicing their legal traditions. And this is how their traditions were passed on. It was through oral communication. And that's what we have today.
It's your burden though. Do we agree with that?
Oh, sorry, could you elaborate on that?
The burden is on you. Are we on the same page here?
The burden's on.
You have to provide evidence to satisfy this, well, satisfy the trial court, I guess, but you have to provide evidence. Are you giving us enough?
Right, so we are providing evidence in accordance with the purposes of Section 35 and what that encompasses, as well as the trial judge's finding in which Michael Marchand and Mr. Desautel have demonstrated what it means for them to be connected to that ancestral land.
But your colleague is arguing the trial judge made these findings and we can defer to the findings, but the legal analysis was wrong and that the conclusion that was drawn was wrong. I'm really interested to know if you have more to provide than just this oral evidence. And maybe I'm not being fair. I shouldn't say just, that can be powerful evidence. But do you have more? And if not, is what you've had enough to satisfy your burden, which I do believe is on you? Right.
So another example that we could turn to is not only the Queen and the Sparrow, but as well as Mitchell and Minister of National Revenue. As I've stated before, that it discusses.
Counsel, you're giving me cases. I want to know about your case. Okay. I want to know about your case. What evidence do you have to satisfy these tests?
Another piece of evidence that may answer your question is the Royal Commission on Aboriginal Peoples. It was highlighted that the Aboriginal perspective and the identity of Aborigines lies in the heart of their existence. And it's essential to groups living in the city or urban areas. And in this case, whether Mr. Desautel is living in America or in Canada does not change the fact that he still has that ancestral connection to the land in Canada. The cultural identity is strictly related to the ancestral territory and land. It provides for a sense of belonging, a closeness to their elders and their homes. So when Mr. Desautel was asked what it meant for him to be hunting in the same ground, to be in the same ancestral land, he states that when I come up here, I am walking with the ancestors and God. I just think about the times that we're going up the mountain like this here. They're not only heart-moving statements, but they encompass the truth of culture, of their cultural identity and what makes them unique and what makes them different. In conclusion, the issue at hand is modern-day successors like Mr. Desautel have not given up their right to the land nor their cultural identity. Their roots are planted in Canadian soil, and to weed out one would mean the downfall of reconciliation. Respective Chief Justice and Justices, it's in the hands of this Honorable Supreme Court to, with the utmost regard to the Aboriginal perspective, plant the seeds for further reconciliation. Subject to any questions, these are the respondents' submissions.
I'm going to jump on what you just said. Why is it this court's job to plant seeds? Why isn't that Parliament's job?
it's a job of this court to plant those seeds for further reconciliation, because it's in our hands to understand that the purpose of Section 35 was not only to recognize and reaffirm, but it was also to reconcile and to recognize that Mr. Desautel and other members have this ancestral connection to that land, and their oral evidence, as is done by their legal traditions and has been done, is being passed on, and it's their oral evidence is justified, and their oral evidence is enough for us to understand the deep connection that they have to this land. Thank you, Justices.
May it please the court, I will proceed. Right. Good afternoon, Honorable Justices and Chief Justice of the Supreme Court of Lions Cup. My name is Lila Belsey. In support of the respondent's position that the Supreme Court of Canada correctly found that the respondent, Mr. Desautel, satisfied the continuity element set out for Aboriginal right in the Queen and Vanderpeet at the Supreme Court in 1996, I will be making two submissions today. My first submission in regards to any potential issues arising from brief lapses in land use and occupation by the Sinixt people in British Columbia. Any ambiguity that potentially arises from these lapses, the court must find in favor of Mr. Desautel. Second, the lapse in question is not a significant enough portion of time to negate the sheer volume of time that the Sinixt maintained their practices prior to European contact and following European contact. And to ignore this fact would ignore the Aboriginal perspective on the matter. To begin with my first submission, issues of ambiguity in line with the provisions of the Queen and Vanderpeet must be found in favor of the Indigenous person in question.
Why?
It's set out in, thank you, Justice, it's set out in Vanderpeet by Chief Justice Lemaire in paragraph 25, that when there is an instance of ambiguity, it is owed to the Indigenous peoples through the fiduciary duty of the Crown to find this ambiguity in their favor.
Certainly you could see problems arising from ascribing a fiduciary duty to an indigenous group that is located outside of Canada.
To answer your question, Justice, I see how the appellant could see this as a problem, in that it would create additional work for the Crown. However, there's no.
I'm going to narrow the scope of my question in that I'm not speaking to the issue of creating additional work. I'm speaking to the issue of how does an agent of the law in Canada ascribe a fiduciary duty to someone that is not within the system of law?
We're submitting that we need to consider, as Canadian legal professionals, the validity of the modern day successors of the Sinixt tribe who are an Aboriginal people of Canada. And it is our duty within the law of Canada and within the context of the Crown, with the purpose of reconciliation in mind, to consider these peoples as subject to our Canadian legal proceedings, as they are. So when Mr. Desautel follows the long tradition of the migratory hunting patterns between the southern half of his traditional territory in what is now Washington to the northern half of his traditional territory in what is now British Columbia, this is a traditional practice that he's following. And in order to follow this traditional practice, he is becoming subject to
Counsel?
the Canadian law.
Counsel,
Yes.
is he the only one that is practicing this cultural practice?
No, I would not submit that at all. The trial judge found that there is a continued practice of hunting by the Sinixt people within the Lakes Colville Confederation within the state of Washington. Now, my friends would like to submit that because this, pardon me, if I could get a moment's indulgence while I find my feet here. Thank you. There is an issue that arises in the view of the appellant that there is a lapse in time where the Lakes Colville tribe were only practicing within the southern half of their traditional territory. However, there are multiple instances of colonial infringement upon Aboriginal territory, and this is what we would submit is fettering these people's ability to practice their traditional migratory pattern. However, they do continue that practice as best they can within the southern portion of their traditional territory. And in traveling in a migrational hunting style towards the northern half of this traditional territory in West Kootenay in British Columbia, Mr. Desautel is following in the traditional practice that was established millennia ago by his ancestors.
But counsel, they took in, what is it, 80-year break. And all of this happened and the Constitution came about during this period, and they're not there right now. So can you please reconcile that for me? Because I'm having difficulty with that, and I expect some of my colleagues are as well.
Absolutely. Thank you, Justice. I would not submit that this 80 years could be considered the Lakes Colville tribe taking a break. There were a multitude of factors that were very significant in the fettering of this migrational style of practice. Initially, we have the creation of the Oregon Boundary Treaty in 1846. Secondly, we have the 1896 Game Act, which explicitly outlawed Aboriginal hunting in British Columbia, under which the Wildlife Act is what Mr. Desautel is charged under today. So this is a continuous extension of this act that was enacted in 1870 or 96 rather. In addition to that, the trial judge also found that there were increasing instances of gun violence and death on behalf of European colonialists towards Indigenous peoples. However, despite all of these practices and these threats of violence and these colonial boundaries that are imposed upon these people, the Lakes Colville tribe continued to hunt in this territory until 1930. So we would submit not to look at this lapse in the migrational hunting practice as evidence that the Lakes Colville tribe has abandoned their right to create this traditional practice. In fact, this court has never—
Why not? Why should we not take this 80-year gap as an abandonment of their rights?
Thank you for that point, Justice. We submit that it would be helpful to keep in mind that the Supreme Court has never found that a constitutional right can be abandoned by disuse. And
okay, but it's being suggested to you that is in fact what's occurred here. So I'm asking you, why not? What is your argument for why you think we should agree with your position that the right was not abandoned for the 80 years?
Thank you. Pardon me while I just— my submission on that point would be to ignore these factors, the creation of the Boundary Treaty, the Game Act, and the instances of gun violence and death would be, and when we consider this lapse in migrational hunting. If we ignore these factors and just say, why does this 80-year gap exist? We are ignoring the Aboriginal perspective on the matter. We are ignoring the tribulations that they faced as a result of these colonial boundaries and these confrontations with European settlers. And instead, we are adopting a mindset that is shrouded in colonialism and not with the fiduciary duty that the Crown owes Aboriginal people when considering these questions of right. To respond—
okay, but aren't there then policy concerns, such as those raised by the appellant, about how much of a burden these rights coming from south of the border could be on the Canadian taxpayer, on the Indigenous groups here. How do you address the floodgates concern that was raised by your friends for the appellate?
Absolutely, I would like to address that. To first examine the floodgates argument, I think we need to consider the high level of evidence that we require for Mr. Desautel to establish this Aboriginal right. And if we're arguing that other individuals like Mr. Desautel, who belong to groups like the Lakes Colville tribe, who have a history of occupation of Canadian territory, but not necessarily an immediate occupation of traditional territory, we are requiring a high level of evidence found. And while inviting this potential for groups who reside outside of Canada, but do have Canadian history to exercise rights on Canadian soil, we are requiring this high level of evidence. And I would submit that it is very possible that not all of these groups who would try to submit this right would be able to meet the high level of evidence standard that we're requiring of Mr. Desautel.
So you're saying there's a high level of evidence standard. I agree. Justice Cote found, paragraph 137, in the absence of even minimally cogent evidence, this conclusion seems inescapable. So Justice Cote feels that you didn't even come close to meeting that evidentiary standard. And all I've heard is these oral traditions. And if you read the paragraph 136, the little portion from Mitchell, it talks about that, and it talks about that we shouldn't treat this evidence as being of higher value than other evidence, and we need to look at it in that context and on an equal footing to other evidence that this court might see. So how is there this evidence that you're saying is so cogent here?
Well, my co-counsel submitted to you the relevance of the oral history that we accept from Indigenous groups, as oral history is a longstanding part of their legal tradition as an autonomous society that existed pre-contact. So we submit that that satisfies some of our evidentiary requirements. However, we also submit that there is no notion that this land was ever forgotten in the minds of Indigenous peoples. And I'll take you to the incident that occurred in 1972 when Mr. Charlie Quintasket, a member of the Lakes Colville tribe, crossed the border into Canada and inquired to a Canadian Aboriginal scholar, Dr. Kennedy, as to why there were no longer any Lakes Colville reservations on the land, which there likely would have been had the Crown not immediately re-seized the land following the death of the last member of the Arrow Lakes Band, a sister group to the Lakes Colville tribe. So this instance, in our minds, not in our minds, we submit is evidence of the fact that there is a continuation of the remembrance of this land, and there's a continuation of an attempt to connect with this land. Respectfully, Justice Cote's argument that the flexibility in which one should interpret a continuity element has its limits. We submit that this is not correct as it is laid out in Vanderpeet, that there's no need for an unbroken chain of continuity.
Counsel, do you have other submissions? Because I like your argument about continuity. So I'm curious to know if there's anything else that you want us to consider with the limited amount of time that we have left.
I would happily submit that to you, Justice. Very quickly, I will submit to you that when we look at the trial judge's findings of thousands of years of pre-contact practice, this 80-year gap is minuscule in comparison. And when we consider the time of contact, there's over 100 years of established hunting practices by this territory, by this nation.
Let's say I disagree with that point you just made. Should I still defer to the trial judge?
Sorry, you disagree with the point that...
Let's say I do. Let's say I disagree about this 80 years being minuscule. Does that matter? Should this court defer to the trial judge? Or is the appellant right that this creates a legal problem?
No, I would argue that we do need to refer to the trial judge and her findings, that this long established practice is evidence that this small lapse in time is not significant. To conclude, the respondent respectfully requests that the court dismiss the appeal and answer the constitutional question in the affirmative. Subject to any questions, those are the respondent's submissions. Thank you.
Thank you all very much for all of your submissions. The judges will now deliberate. So if everybody besides, of course, the honorable justices could kindly clear the room using the leave breakout room button, we would appreciate it. You will not be permitted to re-enter, of course, because there is no judge feedback, but please stay in the courthouse lobby for further advancement announcements. Thank you all very much.